excuse me, like estate planning didn't always seem like something that was for me or for people who looked like me. And thankfully, I have learned that that's not the case. Estate
Right.
planning, I like to put it as just, it is making a plan. And the word estate, granted, people often associate that with, this large piece of land, mansion, or a bunch of assets. The estate essentially is just your belongings, the things that you own, your assets, at the time that while you're alive, as well as when you pass. Legacy, um, is a gift by will, especially of money or other personal property. And it's something that's transmitted by or received from an ancestor or predecessor. And I pulled this from, from Webster's. This is the dictionary definition of legacy. And like I said, this is why I like to focus on kind of framing it as legacy planning, because we all have something. We all have a legacy, even if it isn't what we typically think
Right.
it is. Um, hold on, sorry. So yeah, so it could be, I think if you think of the standpoint of, who are you? People always say, they don't remember you for what you did, but how you made them feel. So even if you don't have property or a lot of money to leave, there could be tangible items that you have. It used to be kind of that joke of when grandma passes away, who's gonna get her cast iron skillet, or who's gonna get the coat or the jewelry. So even those things are a part of our legacy, are a part of an estate, and are worth taking the time to make a plan for. So that's the overview. And I kind of already talked about this, but estate planning, it is the action of arranging a person's life before their death. And the benefits of this is it minimizes effects of taxes, things, generation skipping. It goes a long way in terms of keeping wealth in the family. It also, just from a practical standpoint, it makes life a little easier for your loved ones once you have passed, because when someone passes away, you're grieving, you're dealing with it. That comes with its own amount of stress and just kind of anxiousness around it. So if there is no will, there is no plan, you're dealing with trying to figure out how to cope with the passing of a person, as well as now, oh, I got to figure out how to sort through the details of, one, which I'm sure you've seen people creating GoFundMe's, trying to pay for the funeral or raising money to pay off medical bills or different things like that after someone passes, especially when the death is unexpected. And so creating a plan helps to minimize all of these things, and make life just a little bit easier for those who you leave behind. So, like I said, if you fail to plan, you plan to fail. Do you have any questions or any thoughts? I'll pause.
Okay, so when we think about leaving like legacy, I'm happy you broke it down like that because now I don't know, it just makes a little bit more sense to me because like we were talking about earlier, like when I think of estate, I'm 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 like, okay, I don't really have any property to kind of like
Mhm.
so um legacy makes sense now that you put it in that definition. But is there a difference between legacy and will, or is that the same thing?
Yeah, so there is. So the will is just a physical, it's a physical document. So a will is and I'll just go forward to that so I have it up here. A will, it's a written document essentially that lays out all of your plans of these are your desires of this is, hey, when I pass, I want to be buried or I want to be cremated. I want to leave my house or my car to these people. I want to donate a certain amount of money to a charity, to a university. If I,
Mhm.
there's children, I want this person to take care of my children or to do X, Y, Z. This is who I want to be responsible for actually carrying out my wishes. So I would say a will can be an instrument or a part of the legacy, But I like to kind of think of legacy as, like you said, that bigger thing of who you are, what you did, what you left, what people remember of you.
Okay.
Because so it's, I would say legacy is more all encompassing. And like I said, I use the term legacy planning as opposed to estate planning, but that legacy could include, so I like to break it down of between like life as well as legacy planning, because while we are alive, there are things that you want to keep in mind, especially kind of it before, but even the pandemic kind of brought that to the forefront for a lot of people of, even if something were to happen where you're sick or you're temporarily incapacitated and you're not able to make decisions for yourself, there
Mhm.
are documents you want to have in place for even while you are alive. And so that would be an advanced medical directive, or some people refer to it as a healthcare power of attorney, and then a power of attorney. So these are two, and there's even, for, I always say for people who are younger or single, these are ones you definitely want to make sure you have, because a lot of times people figure, oh, I don't own property, I don't have children, it's just me, I don't need any documents. But you really do, because if you, God forbid you get ill, or there's an accident and there's decisions need to be made about your medical care, it makes things a lot easier if you have already taken the time to designate, hey, I want person X to be the one who make these decisions for me if I'm not able to with respect to my health. Or with the power of attorney, it could be one where it's a temporary one, where sometimes they're used if someone is doing some type of real estate transaction and they're not available, they need someone to step in on their behalf for that limited period of time. Or it's, hey, if I were to become, in the event of my incapacity, I want to give person A the ability to essentially step in on my behalf, act on my behalf, and make decisions. And with the power of attorney, it is very powerful because you are giving someone the authority to essentially enter contracts on your behalf, to open bank accounts, close bank accounts, uh, conduct business on your behalf. But
Mhm.
they are, with the big thing that to keep in mind with those is it has to be, so if I have to give someone power of attorney. You can't get it or give yourself power of attorney or make yourself someone's healthcare proxy. They have to do it themselves. And so those need to be created and signed when the person is of sound mind and able to enter into a contract. And I bring that up because oftentimes I get calls or questions specifically around the power of attorney when there has been some unexpected illness, or with people as they get older, the children will call and say, hey, I need power of attorney for my parent because XYZ has happened. And unfortunately, a lot of times when they're seeking that power of attorney, it's too late because the parent or whomever they're calling about is no longer they're no longer conscious, or they're not considered to be competent by their medical provider. And so if they're not competent, they cannot grant a power of attorney. And then you have to go through the process of establishing guardianship, which will give you the same ability in terms of being able to make decisions and enter into things on behalf of someone else. But it's a much longer and more involved process. And it also requires you to go through the court.
Mm. Okay.
So that's where those is, I would say, in the advanced medical direct, both of them, with both forms, most states, and North Carolina, Virginia as well, have a statutory form, so like a standard form that they've created that you can use. And so you can create it on you can fill it out on your own, or you can work with an attorney or someone to create one for you. With the advanced medical directive, it needs to be signed by the person granting that authority and then witnessed by two people. For the power of attorney, and you want to make sure it's a durable power of attorney, that has to be signed by the person granting it and then witnessed by two people, as well as notarized for it to be valid. And you want to make sure it's notarized, especially if it needs to be presented to a financial institution.
Okay.
Okay, so we already went over, so like I said, the advanced medical directive and the power of attorney, those are documents that are relevant while you are alive. Once the person passes away, those documents are no longer valid because it's not a need. So once you've passed away, that is a matter of, is there a will? Is there a trust? Is there some type of documentation in place where the person put a plan in place and said, this is what I would like to happen? So before we even get to creating that, I feel like a big thing or big challenge is how to have that conversation, because oftentimes people, we don't want to talk about death. It feels
Right.
morbid. People feel like, oh, if I talk about it, it's going to happen. All these different kind of emotions and fears around it. But the truth of the matter is that we are all going to die at some point. That is kind of one of the guarantees that we have, but it's a matter of when. And although it's not the most comfortable conversation to have, it is a necessary one. So I always encourage people to just do it. Just start the conversation. It doesn't have to be, hey, we're going to sit down today and figure everything out. It can be over time. And I always encourage people to start with yourself, of just thinking about, what would I want? Like, do I want to be buried? Do I want to be cremated? Because a lot of times that's not something we've necessarily thought about. Um, but I would say, identifying your goals, like, what do you want? What do you want your life to be like while you are alive? And in the event that something were to happen, do you have things in place to make sure that you can continue essentially kind of living the quality and standard of life that you're accustomed to? If something happens and you end up becoming, you're no longer able to work, either for a short period of time or a long period of time. Do you have disability insurance in place, or do you have money saved up to make sure that you can cover your expenses? Is there someone who you would want to be in charge of those decisions or managing your finances if you are not able to do so? Who are your loved ones? Is there anyone that you are responsible for, or that you take care of, or you would want to provide for in the event that something were to happen to you? Do you have children? Are there any people in your life with special needs who you are responsible for? What assets do you have? So even though if you may not own property, do you own a car? Do you have, or there's like a big collector's item that you have? Do you have a large art collection or jewelry, things of that nature? Like, what would you want to have happen? Who would you want to have them? Like I said, I mentioned burial or cremation. Do you want to be an organ donor? Some people say, hey, I want my body to be donated to science when I pass away. Is there a specific place you want to be buried? I know for a lot of veterans, they would like to have a military funeral, or they would like to be buried in state in one of the national cemeteries. So if that's the case, those things require some advanced preparation. So just having those conversations. Do you want to donate to a sorority? Do you want to donate to some other charitable organization? And then, do you have any insurance policies or investment, like brokerage accounts? Because with insurance policies or brokerage accounts, essentially any account where a beneficiary is designated, those funds or assets are going to pass to whomever is listed as a beneficiary. So you can't put those things, don't pass through a will or any other instrument. They're going to, so if you, let's say you create a will and you say, I want to leave, my insurance, the proceeds of my insurance policy, I want to leave it to my mom. And I can write that in my will. But if let's say my life insurance policy lists my child on there as a beneficiary, then they're not going to give that money to my mom, because that's not what's in the contract or what's in the document. So those are some of the kind of the key things to think about. Even with burial or cremation, there are plans available to where you could pre-plan your burial or cremation. You could even prepay through funeral homes for what you would like to have happen. And you can plan it out in advance. So essentially kind of get as detailed as you want to up front, or just say letting people know what you would like to have happen. Okay. So I touched on this a little bit already, but let's say we're fast forwarding, and so let's say that a person has passed away. So these are things that are going to happen whether there's a will or not. You're going to contract with the funeral home, and to decide, who you want, if there's going to be a service or if there's going to be a burial or even a cremation, you're coordinating with them to have them pick up the body, and go through that process. There will be the death certificate issued, and you want to make sure you're getting multiple copies of that death certificate because you will need to provide that to various entities. So for life insurance, if they have a life insurance policy, you'll want to contact contact that company to notify them that the insured person has passed away. They will want a copy of the death certificate. The same as if there are any pension or retirement plans that the person was participating in, and you'll want to speak with them to notify them that the person has passed away. So these are things that are going to happen, like I said, whether there's a will or not, or some type of plan in place. If there is a will, then hopefully it spells out, like I said, barring the life insurance piece, it'll say whether or not they want to be buried. Some even specify which funeral home or which where they want to be buried, and they have all of those details in there. And so you just follow those instructions. If someone passes without a will or a trust in place, then what happens is their estate is handled through intestate succession laws. And essentially what that means is every state has gone through and kind of thought about how they think people would want their estate to be handled. And so it spells out what happens if someone passes without a will. And so, for example, generally, if it's a person who is single with no children, the state gets a portion, and then the remaining proceeds or remaining estate goes to their parents if the parents are still living. If not, it will be split between their siblings. If a person is married with children, then a portion goes to the spouse, and then the remaining portion is split between the children, and so on and so forth. And so in some cases that might reflect what that person's desires were, but I kind of call it or refer to it as the Cinderella effect. If you have a situation where there's a mixed family, if you have someone where they were married before, they have a child from a previous relationship or marriage, and they've remarried when they pass, they may want specific things to go to their child and not necessarily to the spouse's children. Yeah, go ahead, Tiffany.
Okay, so I think I heard you say this. If there's no will,
Mhm.
then the estate goes, a portion of it goes to the state, and then whoever's left behind.
Yes, and so it varies by each state, but there is, and I can say for North Carolina, and I don't think I have it in here, but yeah, so there's a percentage or portion um that that the state gets. So they get their cut,
Oh wow.
and then whatever's left. And so an example of that is, if you remember when Chadwick Boseman passed away, he didn't have a will.
Hmm.
And so it went through the courts. It took a while. And so there was a portion, the IRS is always going to get their money, but the state got a portion as well as like kind of just the administrative fees. And then once all of that was sorted out, the remaining, and in his case, there was, his family still got a sizable amount of money, but what was left was split between, I believe in that case, between his parents and his wife. The same with Aretha Franklin. She passed in 2018. It wasn't until, I want to say, last year that her estate was finally getting to the point to be the place of being resolved. It wasn't fully closed yet, because it was tied up in court for several years. One, because they found at least 3 or 4 different versions of a will where there was an attempt. None of them were deemed to be valid. There was also some tax issues, so it was a matter of figuring out how much was actually owed in terms of federal taxes to the state. There was also some things in terms of some of the record companies that she worked with, and then also the children kind of going back and forth about who they felt should get what. And so from 2018 to 2023, there was all of this back and forth, and that's court costs, attorney's fees, administrative fees, all of those things that in her case ended up being upwards of millions of dollars that the family does not benefit from because it all had to be paid out. So they end up splitting whatever is left. And so that's another reason that there's a benefit of one of the other benefits to making your own plan, because then you get to say, this is who I want to get what, excuse me. And depending on the size of the estate, it minimizes the cost that the family would have to pay, or the heirs would have to pay.
So that's my question. It's outside of the portion that the state get is outside of like taxes and stuff. Like is the portion considered taxes, or is it considered like, oh, this person died, I'm gonna just get a cut?
It's separate. So yeah, it could
Oh
be,
wow.
yeah. And so I should say it's not always, so if we're talking, like I said, with someone like Aretha Franklin or Chadwick Boseman, theirs is a lot larger number. If it's, because most states have it set where there's a kind of a small estate, regular size, and then it above. So most of the thresholds are millions of dollars. So it doesn't always negatively impact everyone the same way, but it's still something to be mindful of. So I guess in a way to a kind of a practical way of it. So if I have a case where I'm working where there's someone that essentially we can't find one of the potential heirs. And in the event that we're not able to find it, the way Maryland law is that a portion of the estate, or essentially that person's portion, would have to be paid into the state, and it goes to like an education fund. But that's money that the family does not get. Or, in the event that the estate is just property, the property may end up needing to be sold so that a portion could go to cover those fees. Does that make sense?
Yeah, that makes complete sense. I did not know that. Thank you.
Yeah, so like I said, it's not always an exorbitant amount of money, but it's if we're saying, hey, there's $10,000 left. I gotta pay the court costs, and then if in an event I do have to pay the state something, I'm potentially losing 2 to 3 grand that that person could have kept to use towards whatever they were going to use that inheritance for. Like I said, and I'm very broad. My goal is, like I said, as we have future sessions, can kind of dig in and focus on specific aspects a bit more. So I've kind of talked through this already, but probate is the process of essentially distributing the assets when a person dies. So the probate happens whether there's a will or not. It's just, if there's a will, you're essentially just, hey, we're going to carry out the wishes that the person has expressed. If there's not a will, then you're going through whatever the intestate succession laws say would be how it would handle. So you go through the register of wills in whichever county of the state you're in. Like I said, you need to provide them the death certificate and a will, or a statement stating that there is no will. You're paying a fee, and that's based on, each state has it, but where I was saying there's a small estate, regular estate, or large estate. They have established what the fee is to file or open established probate. And so if there is a will, the will is going to specify who is the personal representative or executor of the estate. If there isn't a will, then essentially it would be whomever is the person kind of taking responsibility for that would request to be appointed as the executor or personal representative. And they are the person who is responsible for distributing the assets, doing an accounting of kind of, hey, I'm going to figure out what are the assets, what are the liabilities, are there any debts that are owed, who are the creditors, and having to kind of send out notices to the creditors of, hey, this person has passed away. There's a period of time. It's usually 60 days, 60 to 90 days, depending on the state, of, hey, there's this window of time for you to come and let me know if you are a creditor and there's something owed by the deceased. And if so, if there's, is there money in the estate to cover those expenses? If there is, then those would be paid out, and then it would be a matter of once all of the creditors have been paid and the final tax return has been filed, essentially when all of the expenses have been paid, then you do an accounting to see what's left in the estate. And then from what's left, that is what's distributed to the heirs. So I want to pause because I know I just said a lot, but and you have any other questions?
Yes. Okay. Okay. So probate is the period of when we're trying to determine if any assets or debts are due. Is that right?
Yes.
Okay. And then the person that is designated as the authority, not power
The
attorney,
personal representative or executor, those
executor.
terms are interchangeable depending on what state you're in.
Okay. And that person is responsible for outreaching to like bill collectors and people to say, hey, this person is dead. Let me know if they owe anything.
Yes, that as well as notifying the people, kind of making a list of who could be an heir, and
Mm,
notifying those people. And so if there is, so another thing to keep in mind, if there is property that is being left to someone, you also want to make sure that while you're going through the probate process or the estate is open, they're also taking the steps necessary to have the title or deed of that property changed to the heirs' names during that.
wait.
So essentially transferring ownership of, so if it's of a car, of a
Mhm.
house, you were making sure that's getting done during that process as well.
Okay.
And you can always hire an attorney or having some other type of financial advisor, someone that you hire to help go through the probate process. It's not
Mhm.
required, but if there are a lot of different moving parts, or if you're just not sure, a lot of people do hire an attorney to handle the probate process for them.
Okay.
And the attorney's fees can be paid for out of the estate. So it wouldn't necessarily be that whomever is the personal representative has to come out of pocket for everything. They can use, provided there is money in the estate to cover that.
Okay. Thank you.
Mhm. Like I said, I know it's a lot, and I'm doing just a very broad overview because all of these things have different nuances and caveats depending on the specific scenarios, or specific things. Um, but this here is just a list of things to think about or remember as you're thinking through, how to have the conversation, how to come up with thinking about what you want in your plan, or even if you're having the conversation with other loved ones, to help them with developing their plan. And so I kind of look at it as the same way with jobs. You have annual enrollment each year for your health benefits. With your plan, your estate or legacy plan, is you want to, or anytime there's a major life event or life change, you want to review your documents. So if it's life insurance or pension retirement accounts, check your beneficiaries to make sure that still reflects what you want it to. Checking your documents every few years. Like I said, anytime there's a life or financial change, um, making sure if there's a change that you're updating or changing the name on title or deed of property. Once you come up with your plan, letting a trusted person know, one, I have created, I have a will, I have a trust, I've put these things in place, letting them know, and then telling them where those things are, because it would really, be really bad. Essentially, it would suck if you take all this time to create the plan and then once you pass away, nobody can find it or they don't even know that it exists. And if that's the case, then the court is going to treat that as though you passed without a will or a plan. Um, Even something else that is more would say much more relevant, prevalent these days is also, letting somebody know how you want them to handle your social media accounts. Most of the social media providers they have created something where you can create a list of essentially kind of designated people that if something were to happen to you, these are the people who can access my account to either close it or keep it going. Um, if you have things on auto pay, making sure someone has access to those things so that you're not continuing to make a payment on something after you passed away. Something else that you can do with respect to bank accounts is you can set up some to have a transfer on death or essentially a payable on death that you can establish for your bank account. And what that does is create a beneficiary. And so with that, the benefit of that is when someone passes away, if they have told the bank, hey, when I pass away, this is who I want to have access, that person can go to that financial institution, notify them that the person has passed away, provide the copy of the death certificate and say, hey, I'm the person listed. And then they have access to the funds right away. As opposed to if you don't have that in place and that person's name isn't on the bank account, you have to wait, go to court, open the estate or start that probate process and wait for the court to issue a letter, the letters of administration, essentially giving the bank permission to release funds to you or to give you access to an account. And so depending on what's going on, that could really hinder things, especially if there is, let's say the person has an account where they had money set up to cover the funeral expenses. So there's money there to cover it, but you can't access it because you can't get access to the bank account. Some other things to keep in mind is, if you, like I said, what are your burial wishes? Do you want to be buried? Do you want to be cremated? Do you want to have a service and then be cremated? What do you want to be in your obituary? Do you have a preference or restrictions on who you want to be able to be at your funeral? If you remember, I think it was when Senator McCain passed away, apparently he had put it in his will or in his wishes that he did not want Donald Trump at the funeral. So you can get very specific. One person I know, they've already planned their funeral. They said that's going to be the last party they plan and they want it to be a certain way. But like I said, just make sure you have it documented and that people know that you have taken the time to document it and where to find it and what your wishes are. So I touched on this again, but just kind of reiterating some of the goals and benefits of estate planning is it reduces stress and anxiety while you are alive. And then it also reduces the stress and anxiety for loved ones after you've passed. It will minimize the impact of professional fees, court costs, and taxes. And it also makes the process of administering the estate after the person has passed much more efficient and lot less time and money associated with it. Okay, so that's all I have for now in terms of just, like I said, the overview. So if you have any more questions, or just some other things that you want to talk about, if there's something you'd heard or have been wondering about that I didn't touch on today, let me know.